Welcome to This Week in Introduction to Corrections. This week, we're going to talk about parole and reintegration. So this week, we're going to define parole and the basic parolee characteristics, and discuss the historical development of parole, know and understand the basics regarding state parole, its organization, and its administration. We're going to evaluate the use of parole as a correctional release valve for prisons and talk about the role of parole officers. We're going to look at the common conditions of parole and how parole effectiveness can be refined so we can better meet supervision requirements that are based on offender behavior. Discuss the parole selection process, the factors that influence parole decisions, and what factors are considered when either they grant or deny parole. And then we'll also talk about the process for violating parole, executing parole warrants, and parole revocation hearings. When we talk about parole, what we talk about is the last part of an offender's process within corrections. It is typically going to be at the end of a stay within a prison, and therefore is the last stop before going back into the community, and is considered to be something that is given to them as an award or reward for the behavior that they have engaged in during their stay in prison. The parole as a whole has gone through an evolution over the last several years, in that it only exists within a number of states because of changes in sentencing structures as well as changes to parole in general. Not every state engages in the same type of reentry into the community or has a definition of what parole is. And so we'll be concentrating on those state systems that have a historic and common definition of what parole is. Let's start out by defining what parole is. Parole is an early release of an offender from a secure facility upon completion of a certain portion of their sentence. And while parole has been part of our correction system for centuries, it has a somewhat tortured history in that we've had several changes to it. It's very controversial. And over the last couple of decades, the use of parole has either been restricted in who is eligible for it, under what conditions it can be used, or as I mentioned in the previous slide, it's been eliminated due to sentencing restructuring or the way that inmates are released back into the community. If we look at the current use of parole and who is out on parole within our communities, we find that only 1 out of 8 is a female offender. The percentages have increased over the last several years, and that's going to be in proportion with the number of females who have entered the prison system, and we talked about them when we talked about the female offender in a previous lecture. And so it only stands to reason that the number of female offenders increasing is going to result in the number of female offenders being released on parole. The percentage of parolees that are of minority, particularly African Americans, tends to be around the high 30% range, and those that are white tend to be around 45%. Majority of parolees that are in our communities are have been convicted of drug offenses, and The other 30% have been convicted of violent offenses. If we consider those who are on parole from around the nation, a little over a quarter of them have been returned to prison for some reason over the last couple of years. And usually it's going to be for violating their parole. The highest percentage, although that percentage still remains fairly low at about 16%. But for those going back for a new sentence for committing a new crime is basically about half of that. And so as far as looking at what the types of characteristics we're dealing with when we're talking about parole and parolees, they're wide, they're varied, there's still a lot to be done when we're talking about parole and the system in and of itself. But to get a really good handle on what parole means to the correction system, we really need to start at the beginning. And so therefore, in our next slide, we're going to talk about how it started and who was instrumental in actually bringing forth the concepts of our modern day parole. If you can recall in an earlier lecture on the history, we touched very briefly on the changes to systems in the 18th and 19th centuries with men who were trying to do some reforms to how inmates and offenders were being treated in different areas of the world based on what they were trying to do with offenders in their particular jurisdictions. And the development of parole and what we consider to be our modern day parole really was the work of two individuals who worked in separate areas of the world but were part of the same governmental fixture, and that was Alexander McConaughey and Walter Crofton. Both were working as part of the English Empire, while Alexander McConaughey did most of his work as part of the Australian system, and Walter Crofton did most of his work as part of the Irish system. They were still part of what was considered the United Kingdom at the time, or England. And so therefore, we'll take a look at what each of these men contributed to the system of parole and why it's important to what they brought forth. Alexander McConaughey and what he brought to the system of parole happened down in Norfolk Island, and if you've taken my Introduction to Corrections class, this is going to be kind of a review, but let's kind of delve a little bit into it. He was placed in command of Norfolk Island in 1840, and with him, Norfolk Island was basically a penal island that you were sent to if you were considered number one to be the worst of the worst. But there was also an expectation that if you were sent to Norfolk Island, you were probably not going to get off that island. It was harsh, conditions were horrid, and so when Alexander McConaughey was sent to command Norfolk Island, one of the things that he brought forth was an idea that he wanted a way to give incentives to the men on that island to earn early release for good behavior, and to show that the offenders could be rewarded for avoiding crime or any sort of criminogenic behavior. And he lobbied for several years to have the English Penal Servitude Act passed, which established several rehabilitation programs for convicts. And with the mark system that he passed, which was a system which was brought in for the duration of the sentence, was determined by the offender's work habits and their conduct while they were serving out their sentence. It was based on 5 tenets and was considered determinate in nature, and so they progressed through 5 phases. So if you looked at it, it was thought to be a precursor to both parole and classification. Alexander McConaughey is thought to be the father of parole, and you might want to remember that. As he worked his mark system with behavior, with the last mark allowing the person to re-enter the community with supervision early from their sentence. McConaughey was considered to be too far ahead of his time. And what happened after he was relieved of his command at Norfolk Island is the next commander came through and returned to Norfolk Island to what it was prior to the command of Alexander McConaughey, which in essence returned Norfolk Island to the barbaric penal island that it was prior to 1840. But with the work of Alexander McConaughey came Sir Walter Crofton, who took over the penal system in Ireland in the 1850s, which had an opportunity to draw not only upon Alexander McConaughey's ideas of the mark system and the classification system that had been identified, but he'd also then had an opportunity to work through the English Penal Servitude Act. And so he came up with the Irish classification system, which was much more detailed than McConaughey's system, and then established the ticket of leave system, which was a permit given to a convict in exchange for a certain period of good conduct. The ticket of leave that was established by Sir Walter Crofton was a way that the prisoner could instead earn their own wage through their own labor prior to their sentence being done. There were other ways that the offender could earn liberties as long as their behavior remained lawful, and this was another way that Walter Crofton's system was considered a prior beginning of the parole that we have learned to embrace in today's system. And so these two men, with their visions of reform and ways to handle the offenders, their behavior while they were within the penal systems that they commanded, and some changes to get them to not only take responsibility and accountability of their behavior while they were in the system, but incentivize what they could do before they entered the community, came up with ideas that we took and then applied to our current modern day ideas of parole. Now, during the 16 and 1700s, what the colonies did was sent criminals to the American colonies under the idea of reprieve and through stays of execution. And so we had an idea of finding ways to use differences in sentencing options to send criminals that could not be handled under the English ways of crime and punishment. And that's how we got a lot of the criminal element that had been sent to the American colonies. It was through the idea of transportation. And so while it is part of the concepts of parole, it is not defined by what we currently see as our parole system. From the 1960s, we saw a lot of changes, not only with how we envision the correctional systems, but how we dealt with those that were getting ready to re-enter the communities. The major thought processes of the correctional system up into the late 1960s was the medical model. And we talked about this briefly during an earlier lecture, is that how offenders were treated really came kind of in cycles. And from the 30s to the 60s, late 60s, we had a philosophy in corrections where the inmates were treated as if there was a medical issue that was wrong with them, and then we tried to define what that behavior was and then treat that behavior. And so with that came the idea of using rehabilitation and treatment, because we assumed through that particular philosophy that their criminal behavior was either social, psychological, or biological, and therefore there was a way to treat it. When there was a turn in that philosophy, which started in the 1970s, then what we came upon was the reintegration era, which was advocating try to find another avenue besides incarceration. And so during the reintegration era, there was a very few inmates who were actually imprisoned. And if they were, it was for very short periods. Probation was actually used more often, especially if the offender was particularly nonviolent. And the method of sentencing most often used was indeterminate sentencing. And so during this time of reintegration, there was a lot of use of the reforms that were looked upon to try and keep the offender in the community, and only use incarceration as a last resort for those that were most violent or most in need of incarceration. What happened is we started to see a change in political platforms, and the ideologies started to change, especially with some major political pushes, especially when it came to the war on crime, the war on drugs, the war on terror. And so from the mid to late 70s, we started to see a shift because we started to see crime rates go up. And so with this came a lot of skepticism regarding whether rehabilitation was the proper use of the correction system, especially probation. And it was fed a lot by the Martinson report, which we've talked about in an earlier lecture. And basically Martinson, who was a criminologist at the time, said that rehabilitation basically doesn't work, that most offenders will go back to committing crimes and therefore re-enter the system. And with this report, we saw a huge shift toward the crime control model. And so with the crime control model, what we saw was the changes in how sentences were dealt with and how they were structured. We saw the beginning of mass incarceration. And with this, through the late 70s and the 80s, we started to see states abolishing parole as an option for those nearing serving their sentences and as a tool to have them re-enter the community. Maine was the first in 1976 to absolutely abolish parole. California eliminated discretionary parole in 78, and then saw states such as Arizona, Delaware, Illinois, Minnesota, Mississippi, and several others started to eliminate parole systematically over the next several years. The federal system eliminated parole with the Comprehensive Crime Control Act in 1984. And as we continue to talk about things like this, we'll start to see that many states decided that with the crime control model that they adopted, they were going to make the inmate offender spend their entirety of their sentence and then put them back in the community. We'll talk about what effects that had a little later on in the lecture. Now let's continue about what happened and the different laws passed that started to eliminate parole as we started to end the 20th century into the 21st. As mentioned in the previous slide, the federal system phased out parole over time. With the Comprehensive Crime Control Act in 1984, the Parole Commission only retained jurisdictions over the offenders that had committed their offense prior to 1987. With the Crime Control Act of 84, it provided for the abolition of the Parole Commission that has followed, and it phased out the Parole Commission Act of 1996, extended the Parole Commission until 2002, but that was only supervising offenders who were still on parole. And the continued use of parole was eliminated, even though the Parole Commission existed for those that were on parole. In addition to eliminating parole, many states implemented determinate sentencing. We also have the truth in sentencing laws, and therefore we, as a result, had crime control model as its orientation through the late 1990s. The costs that have been found because of this particular approach really has been under a microscope over the last several years, because what we've seen is crime rates have lowered, but it's been not really necessarily due to the higher rate of imprisonment. We've talked about this in a lot of different classes that we've had. And so what we've ended up with, because of the overcrowding and the mass imprisonment, is rather than a systematic use of parole, we've had to have mass forms of early release, which in turn can have a threat to public security. And so we're starting to see some of the ramifications of states deciding to phase out or completely eliminate their parole systems, and yet continue with the crime control method of sentencing laws and mass incarcerations, and then you have a system that can't really take in anymore, and so then you're dealing with having to release in mass numbers back out in the community. And what we'll talk about is then you have a group of people who are not prepared for re-entry into a community, and you have a public safety risk. And so over the last 50, 60 years, we're talking about a whole-scale change in principle that is starting to come to fruition in exactly how we're going to deal with it. And as we continue on, we'll start to talk about some of the things that correction systems have started to think about doing. The federal system of parole started in 1910 with the 3 federal penitentiaries that were in existence at that time. You had a parole board, and the parole board was basically made up of the warden, the doctor, and the superintendent of prisons. By 1930, there was one single parole board that was stationed in Washington, D.C., had 3 full-time members that the Attorney General appointed. When the Federal Bureau of Prisons had been formed in 1930, they then performed all the administrative functions. Legislation in 1950 saw that they felt that the parole board needed to have 8 members who served a specific number of terms, and the DOJ took over administrative purposes. When 1972 kind of came around, then they split it up into regions with explicit guidelines for parole release and needing to have written reasons for parole decisions. By 76, the federal parole and supervised process included a reorganization act that included establishing an independent agency within the Department of Justice to serve as the Board of Parole that were appointed by the President and confirmed by the Senate. And then, after that, you had the eventual reduction and elimination of the parole system. And we'll talk about that in the next slide. With the passing of the Comprehensive Crime Control Act, you had the U.S. Sentencing Commission establish the sentencing guidelines, which changed everything to determinate sentences. And with this, the sentencing guidelines, which was then assisting in developing parole guidelines. And by 1987, the determinate sentencing terms made it so that those people were not eligible for parole. And so while official parole and the use of parole boards don't exist anymore, they have come up with a modified version of early release that some federal inmates can get related to their service sentence completion. It's called supervised release, which is post-release supervision. It's a separate part of the sentence. It's administered by the sentencing court, and it's not a parole board decision, but there is a sentencing court that makes the decisions, and if they violate the terms, then there are consequences. Because the Comprehensive Crime Control Act of 1984 really abolished parole, they also then had to come up with another act to help with extending the life of the Parole Commission. And so this was the Judicial Improvements Act. It didn't figure things out by any means. And so you have another Parole Commission Extension Act that happened in 2008. And so once that passed, we have the Parole Commission is essentially trying to extend itself, but for the most part, even though the Parole Commission does still exist, they exist only to oversee those federal employees or federal inmates who have been on parole for several years, not to look over those who are newly, because there are no new inmates on parole. And so they're trying to justify continuing the parole commission even though there's no reason for it to exist anymore. And so with the federal parole system, you have a lot of judicial acts or a lot of legislative acts that have been put in place to not only phase it out, but keep some of it in and keep everybody confused as to there's no federal parole, but there are some federal parole commissions in place to oversee those that are still on parole, but there's no new people on parole. So if that totally confuses you, that's okay. Bottom line, Federal Government Bureau of Prisons has no parole. All you need to know. When we look at parole at the state level, every state has their own structure and implementation of how they do it. And so no two states necessarily are going to be exactly alike. They'll probably be similar in nature. And so what we have and how they put together their state parole boards are going to have a lot of different characteristics in terms of how long they serve, how many people are on the board, whether they serve part-time or full-time, whether they serve in an independent nature or in a consolidated nature, how they figure out whether it's discretionary or how their organizational structure is. And so some of the things that we'll look at over the next couple of slides is looking at what the variations are, how it is in the day-to-day supervision, and some of the similarities and differences that make running state parole offices and organizations challenging and difficult. One of the biggest things is whether the state that has a parole board runs it as an independent parole board or consolidated parole board. And so in our next slide, we're going to look at some of the specifics of exactly what it is to run a parole board at the state level. The process in most states is that any offender cases are assigned to various individual parole board members. Their job is then to review the case so they can make a recommendation. Most of the time, the recommendations are going to be honored, but there are some states that will hold a formal hearing where the parole board members will then talk over everything, share their views, their issues, their challenges. If a parole hearing is conducted when the offender is seeking parole, the members that need to be there to make the decision will be present. But it's also not uncommon for just one person of the parole board to be present. They can be at the institution where the inmate is being held, or the inmate can be brought to them. It just depends. The guidelines for who is allowed to be on parole varies from state to state. So it's going to depend on what types of crimes may have been committed, the minimum amount of time that has been served. Those are some considerations. The thing that needs to be understood is that parole boards have a lot of discretion. And so the parole boards can be influenced by a wide variety of criteria, and a lot of times it's not anything to do with statute or agency guidelines. And so there are tools and analysis that have been used, and some of the things that are taken into consideration have to do with predicting the risk of reoffending. And there have been recent processes in place to try and put together ways to predict whether the offender trying to be released on parole is going to be a risk to the community that they are returning to, based on behavior, previous history, or anything like that. There are other criteria that is used, things like their age, their marital status, their level of education. And so those types of things are trying to be standardized to try and be a risk predictor. But the reality is, parole is used as a mechanism to serve as what we consider to be a release valve. A lot of our prisons are overcrowded right now, and parole is one of those ways that can be used as a way to alleviate that prison overcrowding. And so when that is the case, parole boards may be forced to make decisions that don't follow formal risks assessments, because they have to look at how to alleviate the overcrowding issue and yet make those tough decisions that could be, in the end, a misstep and be wrong. Now, parole boards don't operate without some knowledge of what's going on around them. And so they play a role that cannot be underestimated. They may be under pressure to assist the overall state system. And so their position in the correction system can be politically motivated. State politics and state priorities can be a factor, and they can affect the decisions in some parole board cases. The influences of the surrounding communities can be an issue, and therefore these are all things that come into play when looking at granting parole in a state system. You also look at the difference between independent and consolidated parole boards, and independent parole boards are those that are mostly affected by this type of system, where you have them being appointed by the governor and serving terms. A lot of times they have no expertise in the program in corrections, and so they have a tendency to be in a bubble and influenced because they have no ties to the correction system in general. Whereas a consolidated parole board, they are practitioners or at least have knowledge of the correction system, so they can have a little bit more of an academic viewpoint on the offender who's coming up before them at a parole board hearing. And so you need all of these tools and analysis available to you in order to eliminate or at least reduce the risk to the community without the outside influence of those that appointed you. And that can be a big factor when determining whether to grant parole to somebody or not. Institutional parole officers are those officers that work to aid the offender who is making transition from prison life to community supervision. And so these are often referred to as either case managers or case workers. And they serve not only a security function, so they are going to assess their suitability for parole, but they also serve a reintegration function, because they are providing casework services inside the prison and they have networks that extend beyond prison. So what we're looking at when we talk about the institutional parole officers are those that will provide a way for the offender to start planning and preparing to go back out into the community from their prison stay. What they have to do is help determine that an inmate is suitable for parole, and they will begin a pre-release planning process. This usually is about 6 months prior to when they are set to be released, and it takes them from dealing with case management in the institution to working with them and figuring out how to prepare them for community. And so to have a really good reintegration program, they have part of their responsibility and part of the program is to make sure that the inmate has a good support system, they have all the information they need, and contacts outside in the community to make sure that they can start their new existence. And the biggest thing that they need to do is look at the small things, making sure they have things like clothes and shoes that are appropriate for whatever season they're being released. If they came into prison in winter, but they're being released in summer, making sure that they have, or vice versa, making sure they have those types of things, making sure they have the right identification, making sure they have the contacts for all the community agencies that they need. And so this is a 6-month process. Also, part of this is going to help them adjust to any of the anxiety or nervousness that they're going to start experiencing with this anticipation of going back into the outside world. And so with this is going to be stress and all of the other emotions that come with knowing they're going back home. And so a good pre-release program is going to help psychologically prepare the inmate for their return. So they have interviews and checklists and figuring out how the offender is approaching release. All of this is going to be part of an offender accountability plan, which also is going to be addressing whether restitution needs to be paid, and any particular other arrangements that need to be made for the victims and the community at large. So you have a pre-release plan. You should see within this pre-release plan if the offender has to have an accountability plan. Make sure all of these are in place. And as an officer who is one of these institutional parole officers, make sure that the offender understands everything that is coming up, and the officers need to be aware of the milestones that are coming up for the offender, the stress that it could create, and that there could be disappointment and frustration. And so part of what they need to be able to do is manage that and assist with all of those things also. We've talked about conditions of probation before. We'll talk a little bit about parole conditions. And just touch on it really quick, because they're basically identical to those that have experienced probation, and we talked about probation earlier in the semester. They can be a graduated set of restrictive sanctions depending on if they violate them or not. Terms and conditions are similar state to state, and the conditions are also going to be unique to the offender, that are not as frequently used. So for the most part, when we talked about conditions of parole or probation, this is the same thing for parole. Most states adopt a pretty straightforward set of conditions. Things like you have to report to your parole officer, you need to maintain employment, you need to have an ID, you need to have a residence, all of these. If there are going to be unique conditions, there are going to be for those that are in a specialized category, such as sex offenders or domestic violence or drug abuse victims, things like that. Other than that, they're pretty straightforward. If you start to violate your conditions, then you can see a set of restrictive, graduated set of conditions up into including being sent back to prison. And so that's basically what the conditions of parole are. It's nothing really unique, and pretty much the same as those that are on probation. When we look at reentry initiatives, we're looking at the idea behind offender reentry, which is all activities and programming conducted to prepare ex-convicts to return safely to the community and to live as law-abiding citizens. This came as a result of the Second Chance Act, which was signed into law on April 9th, 2008. It was to help improve outcomes for people returning to communities from prisons and jails, and it was federal grants that were provided to government agencies and nonprofits that would help with employee assistance, substance abuse treatment, housing, family programming, victim support, and other things like that. The federal government was trying to provide attention to the fact that reentry is important, and now they were starting to understand that we needed to change the paradigm of how we treat reentry. And so with that, they came up with what we call a roadmap to reentry. And with that, there's 5 principles that the Department of Justice has come up with that is part of this roadmap. Basically, if you are incarcerated, the inmate should be provided an individualized reentry plan so that they understand what their risk of recidivism is and what the program's needs are that they need to have. While they are incarcerated, they should be provided with several programs and treatment options that will help them be successful when they get released. While they are incarcerated, they should be provided with the resources to maintain the support of their family and others so they have that upon the release. When they transition back into the community, they should have available to them halfway houses and supervised release programs so that they have after continuing care. And then before leaving custody of the institution they're in, they should be provided comprehensive information toward reentry and access to resources so that they can succeed. And so with this roadmap, there now is a paradigm shift, that they realize that people are going to go to an institution, but there should be a way to prepare them fully and give them the support and programming they need, not only while they are in the institution, but to prepare them for their eventual return back into the community. With more communities embracing the idea of reentry as a major force behind preparation of offenders back into the community, there's been the development of reentry councils at all levels of government. They are set up to make communities feel safer by reducing recidivism and victimization, assist those who return from prison and jail to become productive citizens. In the long run, they will save taxpayer dollars by lowering the costs of incarceration. And so by putting together a lot of these reentry type councils, you're going to see different types of councils being structured. And the structures are going to be different. They pool resources from different agencies to try and serve the needs of the communities of which they have at that time. The Federal Interagency Reentry Council provides enough support by bringing together 20 agencies to reduce recidivism, improve public health, child welfare, employment outcomes, helps with housing, and other types of support that they will need. And with this, allows for the focus to be on serving those offenders that need to get back out into the community following their stay within the facilities. For those parolees that do have issues with their parole revocation, Morrissey v. Brewer set up a two-stage revocation process. The first is a hearing that is held at the time of arrest or detention, and where the parole board or other decision-making authority determines probable cause. The second hearing is then going to establish the guilt or innocence of the parolee. Now, also during the Morrissey v. Brewer case before the Supreme Court, it was decided by the Supreme Court that the parolee does have some modified version of due process. He can be given written notice of the alleged violations, and he is entitled to be told the evidence that's going to be used against him. He has the right to be present during the hearing, and he can provide his or her own evidence and confront or cross-examine witnesses. He has the right to have a neutral decision-making body and the right to a written explanation. So while they are modified, the burden of proof is less than an actual criminal trial. The parole revocation officer is usually tasked with the preliminary hearing, that first stage at the revocation process to determine probable cause. They will review the allegations, and the thing to remember is these administration hearings and not held in a court of law. They're routine, and their findings might vary. Most hearings are not going to be complicated much, and if the violation requires a true revocation of parole, then they can decide that, or they can figure out if there just needs to be more sanctions. The revocation officer does not require any legal training, just that they know the laws and regulations within the parole system itself. Gagnon v. Scarpelli was another case that came before the Supreme Court, where it was decided that there are some situations where the offender may be entitled to legal counsel. So the parolees do have limited right to counsel during revocation proceedings, but it's going to be determined on a case-by-case basis, where and it must be done at the parolee's own expense. There is no obligation on the part of the state to provide representation such as this. So that concludes our chapter on parole and reintegration. During this chapter, we defined parole and parolee characteristics, talked about the history of parole, we talked about the basics of state parole and the use of parole as a release valve. We talked about the role of parole officers and the common conditions of parole. We discussed the parole selection process, and we talked lastly about what to do in violations of parole. Your discussion question for this week is, what would you do, on page 474, 475. Make sure you read it from the perspective of the parole officer in that scenario and answer the questions fully in no less than 300 words, using references from the chapter and the lecture in your answer. When you are done with your answer, please return to a fellow classmate, dialogue with them about their answer. Thank you for your attention. Join me next week when we cover the last chapter of the semester, and that will be on the death penalty. Thank you.